All right, well, chapter five. This would see how far we can make tonight, but obviously a pretty long one so far, so we'll see how we do.
I assume we're going to get to adverse possession, and we'll just get into some robust discussion like we always do, and
Yeah.
it's about as far as I'm expecting. So if we get through more than that, great. Um, so this chapter here becomes our kind of the culmination of what we've been talking about the last few chapters. And in fact, Jeff consistently cites back to previous chapters. Here we're talking about a principle, and then here's portions of the other chapters where I've set up what we're going to talk about now. So I like this. This is where we start kind of seeing the bigger picture of what we're doing, and rightfully so. The chapter is named Boundary Establishment. What we are doing is establishing or retracing the boundaries on the ground. So we get into some of our ALTA standards. I mean, here's the first thing, Jeff, for you to start updating. This says ALTA ACSM standards, so that's it's a real first quick thing to start cleaning up there, right?
Yeah,
Um,
well, they're that's the 2011 stand version as well.
Yeah.
yeah,
But the 2011 version, as far as I'm concerned, was a major change, a major shift in the Alta standards. Um, and as I talk about here in these next couple of pages, it's abundantly clear that the purpose of an Alta survey is to survey property boundaries, not just deed lines. And if you're just surveying deed lines, you better not be doing Alta surveys because the title company is expecting a complete and accurate survey, and I think we'll dig into that in later chapters, I believe. But but this was also the first time that any standard that I'm aware of made the distinction between accurate results and precise measurements. And a lot of our standards across the country do not make that distinction. And so a lot of standards across the country um, deem an accurate survey based on measurements. And you've got accurate measurements, so you have an accurate survey. But the question is, do you have the true and correct property boundaries? Because that's what the title insurance company is going to ensure. And we know that there's this little thing called the survey exception that can get removed, and really the purpose of the ALTA standards is for the removal of the survey exception in Schedule B2. And when they do that, then they're insuring the survey. So, and they're insuring your survey, and they're ensuring and you are certifying that you have a complete and accurate survey, which of course begs the question, what is a complete and accurate survey? Well, complete survey is doing all of those things that they call for in the standards. That's a complete survey. But an accurate survey has to do with results. Are you identifying the true and correct property boundaries? And let's make no mistake, we're talking about property boundaries. We're talking about the limits of ownership. And that's what the title company will be ensuring if they remove the survey exception, because they ensure on page 1, it's in the title commitment as well, but in the final title policy that gets issued, as a just it's stock right there on page 1 of a title policy. They are ensuring the survey, and that's the whole reason for doing the survey, is so they can remove the survey exception, and then the sophisticated commercial client, if they are being well informed or well advised by their attorneys, they're going to have that survey exception removed. So now the title insurance policy is not only going to be insuring the title to the property, but they're going to be insuring the location to the property, the limits of ownership that the surveyor has determined and and um, and shows represents on the survey that gets turned into the title company. So that was a major sea change, and it's remained it's remained basically the same. It was remained basically the same in the 2016 standards, and then in the 2021 standards, they, in my opinion, and we don't go into it in this book because it's the 2021 standards. That's the current one we have. They took a few steps back, but it's clear that the Alta standards they're not really retracement standards. They're title insurance standards, and everybody really needs to understand that when you're doing an Alta survey, you're really because they require certain things that you wouldn't have to do if you were just out doing a standard boundary survey and retracing um, existing boundaries on the ground.
So let's stop you right there, Jeff. I think this is a great point that I want to kind of talk about why we're going through this. And just to kind of prove your point, what you're saying is I remember in my upbringing as a young surveyor, as a rodman, getting into crew chief about the time of those 2011 standards. I got licensed in 2009, so it's really kind of before that. But I remember being told on an Alta, the explanation of it was shoot everything, right? That's the way it was taught to me. You just shoot everything. You're trying to represent every piece of anything that you find on the ground. And then it was kind of framed in this way. And I still use this example, but imagine some investor out in New York doesn't want to fly out there and look at the property. So you're doing a survey so they could essentially walk it in a more robust fashion than your typical boundary or topographic survey or design survey. And then we look at, from a PLS standpoint, what are the encumbrances on there? And that was really the basis of the way it was taught to me up until that point. And then as you actually start getting into those standards, we start getting into, the complete and accurate surveys you're talking about. But I am curious to kind of continue this discussion, the differences of the ALTA standards compared to 2011 versus the 2021 that we are today, because we hear a lot more about in the standard that you shouldn't be making boundary determinations. You're showing the deed on the ALTA survey as the title record is, and that's what they're insuring against. And when we look at retracement, we've had long discussion of we are looking at more of the evidence and gathering that evidence and finding a resolution to that evidence. Anyone else can jump in here, but the differences between those two and how they apply to the boundary establishment principles.
Well, let me just respond a little bit to what you talked about, TW. Yeah, whoever buys a piece of property buys it, warts and all. And so every person who is buying real estate is under a duty and obligation to do their due diligence. And you probably, if you're in the Alta survey business, you've probably heard this term a lot. We got to do diligence. We got a deadline on our due diligence, and part of the due diligence is having this complete and accurate survey of the property so that all the warts can be shown, all the pitfalls are shown. And it's not just a survey; they have to do other things too. Other inspections, other the buildings and such. It's all part of due diligence, because once that deed slides across the table and the money has exchanged hands, whoever buys that piece of property, buys all the problems with that piece of property as well. But and to another point that you made, you put the title description on there, and you're supposed to be surveying the title description. But there's a difference, as we've already discussed to a certain extent. There's always a difference between the title to the property, what the title documents say, and where the property is actually located on the ground. And so we talked about this during deed interpretation. I wasn't here for the second half of that, but uh, deed interpretation um, isn't just the measurements in the deed that you put on the ground, because if you just put the measurements in the deed on the ground, more than likely you're going to start driving in other pins where there already are pins in existence. Thus, we're talking about the pincushion effect. So is that really, do those title documents really identify the true and correct property boundaries? That's going to be, that will be the question. That will be the question. And so if it goes to court, let's just say, for instance, all right, the title documents say this, so I'm going to put the title documents on the ground. And now you're in conflict on three sides of your boundary. And then it goes to court. Well, where do you think the property is going to be adjudicated? The property is going to be adjudicated in court by going through all the rules of construction. And we have a couple of, I have a couple of sample cases in this chapter. Surveyor trying to break down the section all over again, and he's wanting to move the entire subdivision 6 by 6 feet. All of the infrastructure, move it by 6 feet. That's 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 the definition of practical location. That subdivision is in its practical location, and you can't just go out there and start slapping math on the ground, because you're going to end up in a lawsuit, just like they did in that case. It's, I think it's the first one we're going to hit here. Uh, I don't know. I don't know if you guys are reading these case summaries. They're a little bit long as well. Appeal by Janet Reed of a permanent survey, blah 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 blah. It's on page 125. That's exactly what the surveyor did, and he was a young surveyor, from what I understand. Went to school, got a geomatics degree, and has no clue. The guy has no clue how to survey property, and there he is out there starting a lawsuit because he's breaking the section down again. And the whole thing was, the whole subdivision was initially started in the late 1800s based on the northwest quarter of the section, or whatever quarter of the section it was. And he's decided that, he's just going to do it all again with math, and then he's going to, worse, he's going to go out there and drop pins in the ground. The only problem is he had pins out in the street, and he had pins overlapping other people's property. Now, apparently there was no Alta survey involved, so it ended up being that his client, Reed, Mrs. Reed, had to put this litigation all on her own. And at some point in time, she went pro se because she couldn't afford an attorney. Now, if the title company had been involved, and Grant Survey had been insured by the title company, Grant's out of business because the title company has money and they will sue. If they have to pay out on a policy, you will be sued, because that's what they have to do. They're not really insurance companies, they're contract companies. And they have a contract that if there's something wrong with the title, then they're going to pay out on the policy. And if they pay out on the policy, they have to, by their charter, they have to get reimbursed. They have to get indemnified by whoever caused them to have to pay out on the policy. And that will be you if you're out there slapping deed dimensions on the ground.
Okay. While we're on the Alta and this portion, before we jump into the court case, a couple other things here. Any other discussions? Do you guys heavy into Alta surveys? Anything to add there, or any thoughts from what you read on that? Martina, go ahead.
Oh, I'm sorry. Go ahead.
Hey, Martina here from Park City. Yeah, we do some Altas. We're not heavy in them, but we do them, and so I'm familiar with Table A. And I'm flummoxed at the number of people, attorneys and title people that when you say, okay, here's table A, let me know what you want from these list of items, and they don't know what you're talking about. Just today I got asked, can you do a simple alpha? And I said, sure. And then we talked about table A. So I had to chuckle. So I don't have any wisdom to give anyone other than give them table A, tell them to make their choices.
Well, and you see this first picture right here. Let me see what the caption says. Typical pincushion corner uh, that I found, and that I think I'm going to find every time I go in the field. So you have an original monument, probably the rod without the cat, and then somebody comes in there and there's only one corner in legal contemplation. So why is that second corner? Why is that second monument there? And I do the same thing a lot of other surveyors do. A corner is a legal concept. It's not a monument, and a monument is a thing. And in a perfect world, they would be one and the same. Well, of course, here they're not because somebody's staking out math.
I see David's hands up. Before we jump over to David, just to kind of add to what Martina said, there is, that's a pretty common one. ALTA is a term that people think is a checklist and they're familiar and they think it covers something, and so there's quite a bit of education that definitely goes on if you get in more and more to those surveys. But I too hear that all the time. I want a simple ALTA, or I want an ALTA survey, and then you sit down and explain what it is, and they want something completely different. They just think it's a known quantity, and it really isn't. David, go ahead. You've got your hand up.
Yeah, thanks. I read this chapter a couple, 2 or 3 years ago, and I don't exactly remember the details of that case, but at the time when I was reading it, I was going through a very similar situation where a surveyor had latched on to an old rusty pipe and called it original from 100 years ago, and then held parallel lines to a street from 100 years ago and called off every fence line on the block and filed a survey. And so I got roped into surveying the lot next door, and found a private record from the 60s that kind of explained the whole story and the provenance of that old rusty pipe and everything. And what I discovered through that whole process was that it is extremely costly and time consuming to go through and try to disprove the half-ass survey from next door when they are this doing exactly what Mr. Lucas just described of setting pincushions basically and drawing lines and disregarding all the practical location or the prior boundary establishment on the ground. And it's painful, and there's no money in it. And I'm kind of reminded of that article that I just read at the back of XYHT, the November issue of how there's no money in these things, and the poor schmuck that relies on the survey is the only one that has any kind of claim, and the neighbors are left out in the cold. So I guess I just want to thank you for writing this, and hopefully it'll affect some change. It's a problem, and it's really an ugly practice that some of us are doing, of slapping math on the ground and hanging our hat on the easiest available evidence that we can find, and then running away.
The biggest problem, and the reason I wrote this book is look at that picture. What do landowners think when they go out and see that crap? They think we don't know what we're doing. They're afraid to call a surveyor out because they know where their corner is. That was that rebar. But now the surveyor, And it can be a lot worse than this, of course. It could be 6 feet off, like in our case, appealed by Janet Reed. The surveyor could be 6 feet off, and then moving fences, I don't know, moving fence. I had a little fence put up in my backyard, couple of years ago, and the thing cost me $5,000. And we're talking about a lot in a subdivision, okay? It's just ridiculous. And here's the other problem, a potential problem is eventually the landowners are going to get the idea, landowners and other stakeholders who know about surveying and know that they possibly need a survey, but they go out there and they had one corner, and now there's 4 more pins in the ground, and which one's their corner? Eventually, they're going to quit calling surveyors to come out and doing this kind of crap. And I mentioned this in one of our other meetings, GIS. Okay, we all like to say get it surveyed. Yeah, well, when it is perceived that a GIS map is as good as a survey because the surveyors don't know what they're doing, then it will be. It will be as good as a survey, and we'll be out of business.
I took a call just like that today, and they didn't want to pay the price to go survey it, so they're just, they're going to use the GIS lines from the county to figure out where their lines are, but that'll be a future job to go clean that up when they ultimately don't find the corners and set a fence in the wrong spot. But jumping a little ahead here and keeping us moving, top of page 122, to kind of culminate what we've been talking about here. It says all of this nonsensical activity in every case is carried out under an erroneous perception of a misguided duty. We've talked about it. This chapter talks about it. Brown and how he's recanted some of his earlier writings, right? And how we still glom on to that method of surveying. The surveyors in these cases express the idea that they are following the rules of surveying as they slander a landowner's title, produce hair-raising results, commit negligence, fraud, and other various tortuous acts. In each case, however, deeper examination reveals that the surveyor was either arbitrarily applying a good rule of surveying or applying a totally fabricated and arbitrary rule in the guise of a rule of surveying. What I have found is that it is easier to just read and understand what the law has to say on the subject, especially the law in my own jurisdiction, than it is to attempt to follow some rule of surveying, arbitrary or not. In most cases, the rule of law makes more sense and promotes harmony, where the arbitrary rule of surveying creates chaos and sends the parties into litigation. Continue on here. The problem with this new boundary law principles directive is that too many land surveyors are way more comfortable with their measurement and calculation abilities than they are with the boundary law principles. And I've said it before here, and I'll follow my own sword again. When I start reading these cases, in fact, in this chapter, we've got quite a few cases that are quoted. My mind turns to mush just a little bit, right? But when you actually take the time to sit and read and understand, and the discussions we're having here, it becomes pretty clear what the intent and what the courts are saying. But at first, just to open this up and read it, I kind of get that, right? It's well, this is court. This is above my knowledge, my language base, my expertise is reading court cases. But
well, here's what you're going to get, TW, when you go to court. You're upsetting there's generally a status quo. At least in 40 years of surveying, when I go out to the field, there's generally a status quo. If you upset the status quo, then you're not necessarily going to get there, but you're heading towards a dispute, and then that dispute could ultimately end up in a court case. And what's going to happen when you go to court? The courts aren't going to move the boundaries around. The boundaries have already come established on the ground. And it's not called the common rule, common law, because it makes common sense. But in boundary dispute cases, the decisions generally pass the common sense test. And a lot of surveyors can't just read Janet Reed. It's right here in this chapter. Surveyor went out there and decided that, everything. And here's the other thing, and it's in that case. That's the reason that case is in the book. So then the discussion gets, even with the court, even in the opinion, the discussion gets to the point, well, now, the possibility exists. We got to move every boundary line in the subdivision. No, that's why the boundary establishment doctrine of a practical location is a doctrine of location. We're not going to move. You couldn't do that if you tried to do that in court. And the reason being that your rights as an individual landowner in that subdivision cannot be adjudicated without due process of law. And the only real boundary in question in that case was the boundary between Reed and her next door neighbor. But then the discussion gets into, well, we break this section down, and surveyors get caught up in this crap all the time. I've been in the court cases. I've read the depositions. I've heard the testimony. Well, you can't hold this corner here, especially sectionalized land. You can't hold this corner here without having to change everything else in the subdivision. That is the most idiotic, stupidest thing I have ever heard. A judge on a bench can't do that. The judge has to have jurisdiction over the parties. There have to be papers filed. Everybody in that subdivision would need to be brought into court. And we're never going to bring everybody in the subdivision into court. It's just not practical. So you know what? We have this thing called practical location. It's a boundary location doctrine that is actually used by the courts when these things go to court.
Okay, so I'm going to ask a question here. The next sentence of this, thank you, Jeff, for that. You say this is a failing on the part of the institutional infrastructure of the land surveying profession, and a failing on the part of state boards that allow surveyors to be licensed who are not competent in basic boundary law principles and relevant tort and contract law. So I want to throw those out first to our younger surveyors is, what do your course loads look like, and how many classes do you have in boundary law and or local court case law? And then second to that is us more senior ones. Think back to your schooling. What was that like if you did go to school versus a experienced licensure path? And what can we do to support our schools to bring in a more law-centered education? So starting, I'll repeat those so we can kind of capture that, but any of our younger surveyors in here want to jump in and talk about how much of your course load is actual boundary law or case law?
Yeah,
One
Go ahead, Aiden.
oh yeah, I think he said one class. I don't even remember. I mean, any class. Most of the court cases I did, it was kind of independent study.
Okay. And I will say, Sadao, you unmuted yourself. You want to jump in there too?
Yes, I'm actually in my last semester this spring coming up, but we only have one class, and that one was split between Ohio, Kentucky, and Indiana because we're in Cincinnati. I mean, the teacher was doing his best, but just wasn't enough, I think.
And this goes back to the importance of bringing your younger staff to these state conferences as well, right? I mean, getting them exposed to Lucas and Klein and Kent and all of these, that we can gain all of that knowledge from and understand, the last 30, 40 years worth of history of what's gone on, especially, with Jeff and all of the court cases and stuff like that. I mean, how important it is, but that's why it's no matter what age a surveyor is, they should be at the conferences.
Yeah.
Hell, it just goes back to continuing education in
Yes.
California.
Yeah,
Bring it
absolutely.
on, please.
Right. Great point, David. Great point. Yep. So,
Yeah, I mean, so I can tell you here in Utah, when I went through school, we had Boundary Law 1, Boundary Law 2. They were um, a semester class, so 2 semesters of Boundary Law, and John Stahl taught it, and John's another one of these great speakers, great instructors. But um, the way those classes were set up to support John, we really only had 3 days of class. It was a Friday night and all day Saturday, 3 times throughout each semester, and there's no way to dive in enough to the importance of this. I mean, look at the books we've been doing in Wisdom Wednesdays, and we're going on. I mean, we almost spent a year and a half, 2 years on boundary,
mhm.
but each of these we can get into hours of discussion. So yeah, there's definitely more needed. Matthew, you've got your hand up.
Yeah, I wanted to just kind of reinforce what Trent had just said there. My personal experience was a 2-year program. We did 1 year of boundary law. The first semester was one brown book, and the second semester was the other brown book. But it was really hard to understand that stuff, not having a lot of experience. It seemed really hard to grasp and have context to plant. And now being on the other side where we're hiring people out of these programs, we really don't expect people to come out of a 2-year program ready to resolve boundaries, ready to put, know these tenets of boundary retracement, other than to kind of have been exposed to it. But I really think what Trent said is the right path there. It's like, it's really important now that when you do bring these people in right out of programs, whether it's 2-year, 4-year, or whether they're doing experience only path, you do drag them to these conferences. You drag them to these Wisdom Wednesdays, Mentoring Mondays. You buy them the books. We've bought several people in our office this book, whether they can make these meetings or not, and we try and discuss this stuff. I wish there was a better way to indoctrinate boundary law into the programs, but they seem heavy in geomatics, and they really don't. They're not hearing it from the people who are hiring out of their programs that it's really important that they come out with boundary law. They're getting hit with, well, we need CAD, a lot of CAD skills. We need profiles, alignments, this sort of stuff. That's what we're looking for techs as they're coming out of programs. So again, just reinforcing what Trent said there.
Yeah.
Just
Yeah.
get your employees out there. It's kind of our job to expose them to this broader world of boundary law and to stop the Pincushion effect on our own.
Yeah. It goes back to my point as well. When I'm experience only guy. I did not go to for a bachelor's degree in surveying, but I do talk about just the amount of surveying knowledge you have when you go through a 4-year degree. Obviously, my daughter's going through a 4-year degree, so I get to kind of see firsthand of how much it is. But I mean, you're lucky if you're going to end up with 500 hours of survey exposure throughout your whole 4-year degree program, right? And then it goes back to, like Matt just said, everything's emphasis on calculus on how to interpolate GPS and that kind of stuff, which goes back to this highlighted portion. They're more comfortable with their measurements because that's what they were taught in school versus the boundary law. So I think this highlighted portion is the most most important part of chapter 5. So
Absolutely. And
yeah.
I'll cap this off. We'll keep the discussion moving, but
Yeah.
how important it is for us to be involved in our state societies, right? Give feedback in our education side, be involved in the schools and let them know what's needed, because the curriculum is guided at usually at state level, right? Like in Utah, we have a dean and they have a board, and but if we're not giving feedback to that board, to the school board, to the state board, whatever it might be, there's nothing for them to check against. And to know what needs to be involved there. So we need to give that feedback so they know it. Joseph threw into the chat here, I have 2 upcoming classes in boundary law, boundary and adjacent properties and boundary line analysis. Joseph, where are you going to school? I'm just curious.
Got to be humane.
The University of Maine.
Oh, okay.
Rowan, okay.
Nice.
Okay. James, you had your hand up there?
Yeah, I did. If you want something from the older guys, I started tagging along on survey crew in the 1950s. By the 60s, I was well trained in about everything in field work. I could run the instruments. When I went to work for a consultant engineering firm to start 1970s, they made me a party chief right away, but it was about 1972 that it suddenly dawned on me that what my clients were going to want was to know what their legal boundary was, what they could control by their rights of ownership, whether that, and I decided that was a legal issue, not a surveying issue. And I bought a Westlaw book that I think was used as a textbook for, I think it was called the Survey of Real Estate Law or something of that nature. And that was my beginning. And I never changed from that. As I got older, I felt like if I couldn't tell my client what his legal boundary was that he could control, then I was providing him a piece of paper that was nothing more than fraudulent, because what he wanted to know was what he owned. If I couldn't do that, I was just taking his money. So that's the way I operated. And sometimes my survey plats, or quite often, they add a color of title, which was the guy's deed, just verbatim, and then a survey boundary that didn't look anything like that, but was based on record title that went back maybe 80 years. And then a third line might be indicated on there as possibly being claimed by adverse possession, estoppel, or some other operation of law. And it would drive the title people crazy, and I didn't really give a damn.
Well, thank you, James. That'll bring us into our next discussion, because the next part of this chapter, we'll be getting into some of those discussions.
TW, before you leave,
Absolutely,
because I think it's an important point. You see those last 2 words, contract law?
Yep.
In your highlighted section, yeah, contract law. We have all the money in the world that we need to do the survey right. It's called a contract. And why I say that is, if you get down into the weeds we need contracts. We need basically standardized contracts for the profession. How we would make that happen, I don't know, unless it was part of an ALTA standard, but or ALTA type standard. But so you get out there and you find out that you need to dig up the intersection, find that old section corner, and you don't have to go broke doing it. If your client agrees to do it, then under your contract, then fine, go do it. You got all the money you want, as long as your client can pay. So your contract has to have contingency clause in it, and it has to have a termination clause in it. And so that you can either one can it's got to be equal. Either one can terminate without cause. You can just decide you don't want to work on it anymore. And I'm convinced that lack of a contract is one of the reasons why we have so many pincushion corners, because surveyors get out there and they find out, you know what? I don't have enough money to do this thing right, so I'm just going to slap the deed on the ground and we're going to create a bunch of pincushion corners, but I at least got the job done for $1,000, whatever it is that you orally agreed to. And so when you have $1,000 budget, you're going to get out there and you're going to get it done in $1,000, and you're going to cut corners doing that. But if you have a contract, let's just say you have a $3,500 contract, $10,000 contract, it doesn't matter. You have a contract amount, but you get involved in this thing, and you find out that this is going to take a whole lot more work to actually straighten all this crap out. Then you go to your contingency clause. We've run into a contingency here, Mr. Client. And so now we're going to need more money, or we need to work on hourly rates. And either the client says, yeah, go ahead and go for it. You got all the money you need. The client says, no, I don't want you to do that much work. Then you terminate. Now, this doesn't mean you're going to get paid, but your termination clause says when the contract is terminated, surveyor gets paid for what he's done, to date. It's the only way you'll get your money back on a contract like that you want to terminate. You can't terminate an oral contract without possibility of facing litigation.
And
But
on
what
those,
you'll find,
I was going to say on those points I just threw in the chat. Jeff had done on Mentoring Mondays a couple of years ago, week 63 standardized contracts. And also on week 15, Gary Kent had done one on risk management as well. So for those watching later to go back and kind of watch those, I do try to every January, try to do some type of business contract thing on Mentoring Monday. So again, we'll have another one coming up in 24 on some surveying contract type stuff. So sorry.
Anyway, sorry to
No, I love it.
oh, well, I'm going to add that and bring it back into the book here, Jeff. What you're going to find is the landowner, when you explain the problems and why you need to terminate it, right? Hey, we've got this clause. I need more money for more evidence, right? You've got to do your due diligence of explaining to them the problems you're facing, the challenges you have, and where you're at from a survey standpoint. And more often than not, I find that the landowner, the client, gets it, right? They get that, hey, I'm gathering all this evidence. Here's the evidence I don't have. And a couple things happen. They'll remember evidence that's there, right? Or someone to talk to. They'll come up with something, because just like going to the doctor, the doctor asks you 4 things, 5 different ways, 8 different ways, because they're trying to get the truth out of you, right? Your head hurts, but why does it hurt? And all of a sudden, halfway through the doctor's visit, you remember you hit your head last week, and that's why it hurts, but you're going in a week later, right? And so things will come up and new evidence will be found when you hit pause. Or they'll find that, oh yeah, it's still cheaper than going to an attorney or doing something else, or it's important enough for me to invest more money in this. And I find those scenarios will often happen. So it's a great way to move the project forward too, by hitting stop or pause and having an honest discussion about the challenges you're having with their boundary and why it is. Okay, so jumping back in and continuing that on. So we get into a question of law and fact, and we've had quite a bit of discussion about that here in the previous weeks, but I want to hit on a couple of paragraphs in here. So Jeff quotes out of Brown here, and so Principle 12, it says, surveyors are presumed to know the law of evidence pertaining to the location of land boundaries described by writings, and they are charged with the responsibility of knowing how to apply the laws of evidence when they locate deed boundaries. So right there, I mean, Brown, our one of our go-to books says we are charged with knowing the law, and just kind of continuing that thought on there of what we've been talking about, of it's important for our schools to teach the law first. And then jumping on to page 124, about the middle of that, I've just highlighted another paragraph that stood out to me as I was reading it. It says, worst of all, still other surveys have taken the extra step of recommending to their clients that cross quitclaim deeds be drawn up so that conveyances can be made to correct these problems. And some of these landowners act on these recommendations only to find that the problem rears its ugly head once again when a new surveyor comes along with new measurement and new math. And that's when we get into this court case here. And so understanding, and we're going to get into this with boundary by acquiescence, adverse possession, and some of these things after these court cases. But, the solution needs to be founded in law and described, narratively described, so that there's an understanding of what we did. And certainly that helps in states where you file your survey or record your survey so other people can follow behind your retracement footsteps and have more evidence in there. Jeff has talked a little bit about this appeal by Janet Reed here tonight, and I want to jump into that, but Jeff, as we kind of jump in and roll into the other portions of the chapter, is there anything else you want to pull out of the court case that you haven't talked about yet as we get into some of these other principles that this case addresses?
No, it would take another session to go through appeal by Janet Reed, but
Okay. Anyone else that read through the court case have something they want a question, want to address and point out to kind of keep the discussion going there?
well, the one thing I will say is this case also stands for something I talked about a couple weeks ago. Back um, when I was on James's crew, back in the 70s, we used to work from the inside out. You go find the property, and in sectionalized lands, you got to tie to a section corner usually at some point in time or some other recorded corner. So you go find the property, and we worked our way out, and to find harmony in the neighborhood, to get to that section corner, get that tie that you need to the section corner. And so all the surveyors in this case were working from the inside out, except for Grant, and he worked from the outside in, went out and broke the section down again. He moved the center quarter 15 feet, and by the time it got to these properties, he was 6 feet off. So he had the outside in approach, which was never heard of, to my knowledge, until the advent of the GPS. Because then you could work from the outside in. You could go set up on those section corners and those quarter section corners. You could break that section down, and you could work from the outside in and tell everybody they're in the wrong position.
I like that. That's an interesting discussion there of just field procedures and what we're training our guys on. And it's actually when I plan on following up with my guys in the next couple of days, because at a GPS level, I was trained. We go turn the GPS on, and back in the day, it was a base station. You set it up and hit the here key, and then you go walk out to the section corners and you locate those, and if you use Trimble, you calibrate it. If you use TopCon, you localize it, right? And get everything tied into your calculated points for everything, your office calculations. And then finally, you go walk the site, right? But, after I became licensed and got more and more into this, my first step is always to go walk the site. And often, as a licensed surveyor and a project manager for my company, particularly on bigger boundary retracements, I go walk the land with the homeowner. It's as step one, right? As we're signing the contract, we go walk it with them and get an understanding of what their expectation is, what our capabilities are, what our process is. And I start on that inside out. I didn't ever think about it that way, so I appreciate you bringing that up. But let's throw it out to the group then as a discussion of how you guys do it or how you train your crews to start doing that boundary retracement. James, you have your hand up.
Jeff's gonna hate me, but I'm an outside in guy. I start if it's based on if the title is based on an aliquot part of the GLO, then that's where I'm going to start. But as soon as I get down to my property and I find these pins that don't match that, the first thing I'm going to do is try to evaluate or give them value as being something that's controlling. Because I want to do like Jeff says, I don't want to cause a problem out there. So when I find that point that's out of place, I want to say, are there several tracks around here that have recognized that as the quarter corner? Has it become well known in the community that are relied upon, that monument is going to control these properties? And if I can document that, then it's going to be the control for that smaller section. But then if we go to court and one of these guys comes in there and does a breakdown of the section, I already know why I'm going to say, no, that won't work here. This is being controlled by a monument that is well recognized, that everybody that's concerned with their boundary in this area has recognized and used this monument to control their boundaries. And I think Jeff will agree to me there. When you explain that to the court, you're going to win. The guy that does the sectional breakdown is going to lose. But if you do a sectional breakdown and there's a monument out there and you can't validate it in any way whatsoever, I'm not going to use it.
Well, I would make a point of clarification there. When I go hit the section corners, and I usually try and hit all four corners of a quarter section with which my property resides, but I'm not re-breaking down the section, right? I'm retracing the section ties as they are written in the deed to retrace that. So a couple of things in the chat real fast here because it's going pretty quick and I don't want to miss this. Joseph threw out, living and working in a state without recorded surveys. Do states that have recorded surveys have less pincushions? And the consensus kind of in here is probably not really. I think it exists everywhere. The one thing I will say, having done a little bit of surveying in Ohio and West Virginia in non-PLSS states, in the little bit I did there, I actually found less pincushions in those. They tended to describe theirs more robustly in the deed, calls to adjoiners, calls to the actual monuments. And I think we get a little lazy in the PLSS states where we just do the mathematical around there and tend to leave out adjoiner calls or calls to the actual corners or monuments. And so that laziness in our work in PLSS, thinking it would be easier, may lead to more pincushions there. And then Aiden threw in, where do I get the document shown? So obviously it's in the book. And then I think week 1, we talked about where to get some of the court cases, right? We talked about some websites. Does anyone else want to throw out some of those websites real fast where you can search court cases? And maybe TK, you can throw that into the chat for everybody, would be great.
Yep.
So there's some great resources to find some of these court cases there, and they can be searched online. Okay. I had some other thoughts while we were talking about all that. Now I got distracted with those, so we'll continue on here if there's nothing else. So I'm going to kind of skip over. I didn't highlight anything per se in the court case. I think we've talked about the implications of that. TK highlighted Smith had previously performed a survey for property for Hyde and determined he would have a conflict of interest if he performed the permanent survey. Schmitz's previous survey of Hyde's property differed on the north-south boundary line by approximately 8 feet, and we talked about that.
Yeah, I was clicking buttons and highlighted. Sorry.
Okay, I thought we had something there, so I went with it.
No, sorry.
Okay, so I'm going to jump over to page 130 here. And we go back to this, we quote it. If we were to have a mantra as surveyors, right? The book says, one thing we can say about Justice Cooley and his opinion in Dale versus Zenger is that it never gets old. We continue on here. The fact that courts today still have to refer to Cooley is an indictment on the land surveying profession. Paraphrasing Cooley from that opinion, land surveyors have mistaken entirely the point to which their attention should have been directed. Instead of focusing on trying to make technically correct surveys based on new measurements, land surveyors should be focused on retracement of the original boundaries. The law and equity. Dale was decided in 1878. After 133 years, you would think the land surveying profession would have gotten the message by now. How much longer will the general landowning public put up with this nonsense?
Well, let's just keep them ignorant and they'll never say a thing. That's a bad advice.
Keep doing that till they stop hiring us.
And then they'll get rid of licensing boards, and then we'll have any old Joe who can carry a tape doing surveys. That doesn't sound like that's in the benefit for the safety and well-being of the public now, does it?
Not at all. So on the next paragraph here, it says, in the boundary surveying context, extrinsic evidence is always in play for the land surveyor. Many courts have established rules for when extrinsic evidence can be heard for the proper interpretation and intent of the deed. These rules primarily revolve around the question of ambiguities, patent or latent. However, other courts have said that extrinsic evidence is always admissible when the boundaries are disputed. Boundaries may be proved by every kind of evidence admissible to establish any other controverted fact. This is based on the reality that boundaries will not be in dispute unless some uncertainty is present. The land surveyor should be well informed of the rules of evidence and the difference between admissible or good evidence and inadmissible bad evidence. Nevertheless, the land surveyor is not restricted in what evidence he or she may consider. In fact, I would add there that we should consider all evidence and assume that we have not gathered everything yet, right? There's always going to be something more that may inform our decision. I've said it here before, but now I forgot the phrase. It just left my mind. But strong opinions loosely held, right? I will defend my survey until there's a better piece of evidence that I may not have found that someone else finds, and I'd be happy to review and consider that evidence when it's found or brought to light.
Yeah, that's an important point. I do my best to do exhaustive research and find every bit of evidence that's out there, but it's entirely possible that I missed something and somebody's going to pop up in 5 or 10 years and say, hey, I found this. What do you think? And I hope that I will be open-minded enough to consider that. But what I can tell you is the times that I've found evidence that other surveyors have missed, they usually are dismissive of that, get defensive, and then, and they refuse to make any changes. And so my takeaway is that, I should always be willing to reconsider my opinion if new evidence is disclosed at a later date.
Absolutely. Thank you. Okay, jumping over to the next page, we jump into this Ayers versus Huddleston, and it says right in the middle of this page, in Ayers versus Huddleston, the Indiana Court of Appeals stated, "Is not a question of whether the plat is right. The draft of certain lines in a plat and the description of them in a deed are only evidence of the actual survey. The lines marked on the ground constitute the actual survey, and where those lines are located is a matter of fact to be determined by the jury from all the evidence." The Ayers court is saying is saying is what many other courts and commentators have said before. We also acknowledge that the mere existence of a recorded deed does not, in and of itself, give us conclusive evidence of a party's boundaries. A written deed is evidence of ownership. It is not proof of ownership. If monuments placed on the ground by the original subdividing surveyor in any context represent the boundaries of the respective tracts of the land, then what the boundary is has not changed, even though the current measurements to those monuments reveal inconsistencies with the written deed and or plat. And as an example of this, I dealt with this just last week and this week. We've talked about in parts of Utah, we have what are the old Mormon pioneer lot and blocks. They predate statehood, and they were the original subdivisions of land in some of the city centers. And over time, some of the counties or the cities have stopped maintaining centerline monuments and corners that represent the controlling points of these blocks. And even more so, section corners are being held as a secondary evidence or secondary tie to these boundaries. And the unfortunate thing is, those two languages don't talk. Maybe in a retracement, a more modern retracement survey, because we think we need to tie to these section corners, now we're tying and creating these new descriptions to section corners versus the original centerline monuments or block corners as they may have been originally deeded or created or platted. And we've talked about in here about the simultaneous creation of a lot, in a subdivision or a block and lot type scenario. So we just recently completed a survey and a subdivision of a number of lots inside a block, and so we did the standard practice of breaking down the block, if you will, finding the center lines, finding lines of occupation, and unfortunately, in this case, the original survey for these blocks, the original subdivision doesn't exist, but there are some 1960s and 1970s retracement surveys of these blocks, and the corners they reference, the centerline monuments, don't exist. So we've done our best to establish center lines and blocks and everything. But the interesting thing is that after what I felt was a very robust survey and a very clear equitable determination of the lot lines within all these fit the occupation really well, county recorder is trying to map out my subdivision plat, and I get a call saying, this doesn't work, you're off by 3 feet. And so we had this long discussion of, this is the boundary principles which hold my survey, which hold the way the creation, the simultaneous creation, and how you would, if you needed to distribute error, excess, or deficiencies. We spent quite a bit of time going back and forth, and ultimately never quite got there, but I did want to accuse them of surveying without a license because they're on a desktop looking at an aerial image that doesn't actually fit my subdivision plat, but it fit so perfectly was what we're talking about here. They're looking at some one-off map off to the side and not even considering any of the evidence that I went through into the determination of the boundary lines that fit occupation and everything else. But I love this, what this is saying here is it's all evidence, and you have to gather it all. Martina, go ahead. You're muted.
Sorry, it's been a long day. Hell, it's been a long year. Amen to that. And when I remember, I was super young surveyor, 2 years in Ohio. So someone earlier was from Ohio. We had to do the same thing. There were no centerline monuments. The boundary lot corners were just gone. This is an old, I don't know, 1920 town, small town, 800 people. So my party chief taught me, like, hey, these limestone curves are original. And we split the limestone curves in this small town and recreated the road center lines, and it solved everything. And so sometimes you need to just take your head out of the book, like you and Jeff Lucas tell us, and just look around. It's that simple, right? But I'm gonna say this, and this might be unpopular, you guys, but I'm old enough and been serving a kind of a long time now. So when you're a new surveyor, or even when you're an old surveyor like me, it's scary to put your neck out on the line and say the boundary is here when a whole bunch of other pincushion jerks have said, no, it's over here because my math said so. So I want to put that out there. We should keep this in mind maybe when we're reading this book. Don't be afraid to make a decision, but make it on facts and the law. And that takes a lifetime to learn. That's my 2 cents on that.
I like it. Thank you. Finish off this, move over to the next point here, this last paragraph. Boundary settlement doctrines such as acquiescence, practical location, boundary by patrol agreement, repose, and even estoppel traditionally do not change the what question. We've talked about the what question here quite a bit over the last few weeks. They do not change the what question, but settle the where question. This is why they are considered boundary settlement documents. They settle the where question while leaving the what question unmolested. This is especially true in the face of ambiguities. Ambiguous deeds with more than one possible location on the ground tend to kickstart these boundary settlement documents. However, in some jurisdictions, ambiguities are not necessary for these doctrines to apply. Even if the true boundary line, as contained in the deed, could be ascertained by means of a survey, the doctrine applies and, in essence, rewrites the description of the property. And we quote this case, in the California case, James v. Ledit. And I'm going to read, I'm doing a lot of reading tonight. I apologize, but I think this hits the point of what we want to get out of here. But it says in this summary here, the object of the rule confirming occupation according to an agreed line is to secure repose, to prevent strife and disputes concerning boundaries, to make titles permanent and stable. And the rule not only binds the parties, but also their successors by subsequent conveyances. It is also established by the authorities that the line so agreed upon becomes, in legal effect, the true line, that the agreement as to the line may be in parole. It does not operate to convey title to the land, which may lie in between the agreed line and the true line, but fixes the line itself, and the description carries title up to the agreed line regardless of its accuracy. That the division line thus establish itself to the deed of the respective parties and simply defines, not adds to, the lands described in each deed. And that if more is thus given to one than the calls of his deed actually require, he holds the excess by the same tenure that he holds the main body of his lands. So there's a couple of things that we've used these words. I want to make sure we define them, and one of them we used a few times in our book, but kind of this to secure repose. Anyone want to throw a good definition out there? That was one of those words that we hear, and it's got a definition here following that, but I want to make sure everyone understands some of these legal words that we use, but our young people may not understand. Getting back to this point of let's teach the law, let's teach what these vocabulary words mean.
Well, since this book, I've learned a lot more, in the last 10 years, something like that.
Or 13.
Repose is actually, it's also a boundary location doctrine. And it kind of goes back to the appeal by Janet Reed. The subdivision has already been laid out, improvements have come in, people have built their fences, everybody's happy. The subdivision is in repose, everybody's happy. Repose just means basically sitting back and and chilling. Okay. But a lot of surveyors can't chill. And they have to go out there just like Grant did in appeal by Janet Reed, and they got to upset the apple cart. Cooley talks about repose, and actually the 2009 Bureau of Land Management manual of surveying for the very first time in chapter 3. I think it's 3-137, something like that, 3-173. Anyway, right there where it's talking about um, um, uh, bona fide rights and such as that, talks about leaving these sections in repose. They are in repose. It's been broken down one time. People moved in, they glommed on to the lines and their fences and their improvements. And when they do that, then and they go into reliance on these lines that are long-standing lines of occupation, their property rights actually attached to these things, and we should leave that in repose. Cooley talks about that in his quasi judicial function of the surveyor paper that he wrote for the Michigan Society of Surveyors and Engineers back in 1883. Talks about repose. That was the same deal. He talks about it also in Deal versus Zanger, where the city surveyor came down there, started from 5 blocks up, and brought the measurements down, and ended up throwing the lots 4 feet out into the first lot at the end of the block, 4 feet out into the right of way, and then everybody else was 4 feet off. And so Cooley, just read any Cooley opinion, Deal versus Zanger, read that one. You can look that up real quickly. Repose just means leave it alone. It's kind of like there's a statute of limitations for in the civil context in the United States of America, not the criminal context, civil context. There's a statute of limitations on every activity under the sun. And why do we have a statute of limitation on every activity under the sun? Because life is too short. You can't have these old stale claims hanging out there forever. The rule of repose isn't a statute, although statutes have rules of repose in them. Statutes of limitation have certain ones have a rule of repose in it. But when you're talking about repose as a boundary doctrine, you're talking about it's not a statute, but it's a court-made rule. After a certain amount of time, and usually that amount of time is 20 years. After 20 years, it's a done deal. You leave it alone. The neighborhood is in repose. The boundaries are in repose. It is like a statute of limitations. Repose is. But it's a court-made statute of limitation. And then why did the courts make this this rule of repose, this ultimate statute of limitation created by courts? Life is too freaking short. We just need to leave it alone. After a certain amount of time, just leave it alone. And every state that I have ever looked for it in, there is a rule of repose somewhere in there. It's anywhere between 10 to 20. I think I've seen one out there around 30 years. After that, it's a done deal. It should be over. It's almost like it's a court-made statute of limitation. After a certain amount of time, we're just going to leave things alone, and you're just kicking at the pricks if you're trying to move things around at that point in time. That's what repose is. Leave it alone. You got a status quo, leave it alone. You got a fence that's 20 years old, leave it alone. Because if you take it to court, you're going to go back to the fence.
Thanks, Jeff. Yeah, I like to think about as, you bury a body, you're not always unburying a body. You leave it in its rest, right? Let it repose there. We just don't. But
that's a good one, TW. I like that. When you bury the body once, you don't keep digging it up.
Especially if it's a body you buried, you don't want to go back to it.
You don't want to do that. Don't want to do that.
Okay, so go ahead, James.
I read a court case out of Ohio about 2 weeks ago, and I'm thinking it was Bart v. Hughes. Does that ring a bell with you, Jeff? Anyway, it was a piece of property that had been divided up in a will and went to some heirs, decades before this controversy came out. And then Ohio, I understand, came out with a law that legal descriptions had to close. Is that correct? I'm not sure about that, but anyway, that was part of it, and that started a controversy amongst the boundary between these parcels that had been divided by this will. And we wound up with two conflicting surveys. And one of them, the first one, was by Jeff's definition. I was certainly a deed staker. He took the geometry directly from the deed, tried to put it on the ground, and it didn't work at all. And the next surveyor that came along was smart enough to go out there and say, what are the lines of occupation out here, and how do they relate to the language in these deeds? And he found that none of the deeds closed. The original deeds didn't close mathematically. But whenever we went out there and started looking at the occupation on the ground out there, and then started there with the occupation and tried to find the language that would fit that, he had no trouble matching everything up. So when they got to the court, well, the deed staker had to he got blown away. And I thought that was an excellent court case. What the court said about why you survey in that manner, and that with very old properties and descriptions, your best evidence of what was intended originally, and that's what you're going after. What was the intent is best shown by those things like fences and maybe some old monuments, but occupation and the stuff that the actions of the property owners on the property is a better evidence of where the boundaries belong than some guy that comes along and does deed staking. And I like that court case.
Thanks for sharing that. We'll have to find that one. Thanks, James.
Well, James, that's not the only court case that says that.
I'm sure it's not.
There's a lot of cases that say the same exact thing.
Okay, so in interest of time, I'm going to jump over this this Thuralt versus v. Murray here. I'm going to jump over, so I found this interesting, and I wonder, we talked about this when we were going through Waddles, and I wonder if this is some of the same stuff, but we talked about some differing points of origin in California. And so jumping over to page 135, we continue on here. There must be a finality in the location of boundaries. This is a repose principle. Mankind has recognized this concept for as long as there have been boundaries. This concept is documented in the Bible dating back at least 4,000 years. And the common law has recognized this idea for centuries. If boundaries are subject to new and better measurements based on evidence that is constantly changing, forever in flux, no boundary will ever be settled as to the location. And going back to our evidence and procedures, many of the principles said, the methods, means, measurements, accuracies of the time that deed was written is the method, means, accuracy, and precision which that deed is retraced, right? When we go measure with better equipment and get down to the thousandths of a foot, well, that's changing the method with which it was created. And that's one of the reasons I believe we get pincushions, is because we could just measure better. But if we cement in our minds that principle that was consistently in evidence and procedures, and it's here again, going by the methods that was originally created will help us be able to follow in their footsteps, because we are quite literally following in their footsteps in that method and means. But it's quite interesting. So in the early case of Arena versus City of Santa Barbara, the city passed an ordinance in 1870 declaring certain points in the city as initial points from which all future boundaries would be determined. In other words, all future boundaries in the city would be completely dependent on measurements from these initial points. In ruling the ordinance void, the California Supreme Court made the following observation: this ordinance is void and should not have been received in evidence. The city council could not change the location of streets and highways in this manner, nor could it affect the rights of lot holders under grants previously made. Much less could it lay down rules of evidence by which the courts should determine the location of points, nor determine the fact as to the initial point. Even if it had been made in advance, it would have been utterly impractical and would not have controlled the actual survey. Although they were shown to be incorrect, no absolute accurate survey ever was or ever will be made. In order to build cities and towns, there must be some finality as to the location of blocks and streets. Under such an ordinance, if valid, there could be none. All lines would be forever subject to be revised and corrected or changed by new surveys, not really more accurate, but only for the time so deemed so.
And why, Trent, PW, why was it void? Because it's totally freaking unconstitutional to adjudicate people's rights without due process of law. It's totally unconstitutional. Of course, nobody gives a crap about the Constitution anymore. Nobody reads it. Nobody even knows what it says, but it's there. And it says you cannot have your rights adjudicated. This ordinance cannot adjudicate the rights of everybody in the city based on moving the property boundaries around with the next measurement that comes down the pipe. So why can we do it? The reason we can do it, you know why the reason is that surveyors can do it? Because they can't sue us, because they don't have any money to do it.
Well, Jeff, you got exactly into the point of why I wanted to make sure we hit this court case and this chapter tonight. It seems totally obvious to me to read that there's a court case that says a city council cannot move initial points. I mean, that's a no-brainer to me. I mean, why would they want to even? And I don't know the history behind this. But surveyors all the time move the initial point. We re-break down the section. This center corridor was wrong, and I'm going to move my initial point. But in this example, it is so clear that they can't. So, as you said, why do we?
Well, it wasn't necessarily a TW. It wasn't necessarily moving the initial points. It was having permanent initial points from which we would make all future measurements, and then determine individual lot, the position of individual lots, and that's just the lots over time. We're just going to do this, depending on the measurements. We're just going to keep doing that. We're going to keep moving their property rights around. You can't do that. You can't have your rights. Property rights are rights that landowning citizens have. And you can't have your rights adjudicated without due process of law. That's the reason it was unconstitutional. You can't have an ordinance that adjudicates people's rights the next time a surveyor shows up. That's what this case was all about.
Thank you. So, and finish off this last paragraph here. What the boundary is will only change when there has been a conveyance of land. When the conveyance is unwritten, if such a situation actually exists, then something like adverse possession has taken place. Once perfected, however, adverse possession is memorialized by a written court decree and is therefore no longer unwritten. The boundary establishment doctrines on the other hand, do not convey anything. They simply establish where the boundary is located without changing what the boundary is. When the land surveyor attempts to resolve this conflict by redefining the what to match the where, the surveyor is actually claiming that a conveyance has taken place outside of the deed, an unwritten conveyance. In most instances, this is not the proper approach to the problem.
Yeah, you want to talk about surveyors practicing the law? There it is right there. When surveyors try to change what the property is, the legal question, to match where it is on the ground, they're actually stepping into the shoes of a lawyer, making a legal determination. Locating property boundaries on the ground is not the practice of law because there's no law involved. You're just locating. It's a factual question. That's the question in a boundary dispute case. That's the question that goes to the jury. And guess what? The jury doesn't determine what the law is. If you have a trial and you have a judge and you have a jury, then the judge determines what the law is. The jury just sits there and listens to what the judge has to say. They will listen to all of it. See, the jury is actually the perfect description. We'd like to talk about the surveyor as, as being a judge, but the perfect description of the surveyor's role in retracement surveying is the jury. The jury doesn't determine what the law is. The jury doesn't espouse what the law is. The jury doesn't determine what the law is. The jury listens to the facts, decides what the facts are, and the judge, before they go deliberate, the judge hands them the law and says, here it is. Now you take those facts that you just listened to through this court and you rub them up against this law that I'm going to give you, and you tell us where the boundary line is located. That's what the surveyor does. We go out, we gather the evidence. It's not given to us. We have to go out and gather the evidence, and then we rub the fact and we determine what the facts are based on our surveying expertise. We determine what the facts are. We determine which ones are good, which ones are bad. That's weighing the evidence. We weigh the evidence, and there will be a preponderance, and usually a great preponderance of the evidence leading to one decision, one location over another location. And then we have to take those facts and we have to rub it up against the law. That's not practicing the law. That's what some surveyors just can't wrap their brains around. Do you have a driver's license? The stop sign analogy is my perfect example of the surveyor of the difference between a factual question and the legal question. The legal question is, what is the stop sign? What is it? It's a legal question. It's a stop sign. The factual question is, when you go up to the stop sign, did you stop? You're not questioning whether it's the stop sign or not. No, the question is, where did you stop? And maybe in the boundary context, the question is more succinctly, where do you stop? So, Mr. Surveyor, you have a deed. Same thing as a stop sign. You're in your car. You got have a license to drive. You're driving down the road. You come to a stop sign. You have to make a legal decision. What is that thing? And then you have to act on what the legal thing is. It's a stop sign. You're supposed to stop. That's what you're supposed to do. Is that practicing the law? No. You're a surveyor going down the boundary line. You have the legal question in your hand, the deed. Now, what are you supposed to do with that deed? Well, you're supposed to stop when you get to the boundary. Is that practicing the law? No. That's practicing common sense. That's actually applying the law to the situation, just like a driver driving down a road. You have a license to drive. You have a license to be on the road. You come to a stop sign. You got to make a decision. You got to ask and answer the legal question. The legal question is, what is it? It's a stop sign. What do? You stop. Where do you stop, Jeff? Oh, there's a stop bar down there. That's where you're supposed to stop. Oh, there's an established boundary out there, Mr. Surveyor. That's where you're supposed to stop. And it's not always that easy. Sometimes there's multiple stop bars. Sometimes there's no stop bar at all. But that's not practicing the law. Obeying the law, applying the law, asking and answering the legal question is not practicing the law. Every citizen in the United States of America is charged with knowing the law. Ignorante juris non exclusive. Ignorance of the law is not an excuse for anyone, especially land surveyors who are out there messing around with people's property rights.
Okay, I like it. Thank you, Jeff. I think it's a great spot to stop here. We didn't even make it to adverse possession. That's okay. We'll have some great discussions in January. So, any other questions or comments before we end it for the year? I guess.
What do you do when you find a pincushion stop sign?
That's everyone's homework for the.
Treat it as a yield sign.
There you go. That's everyone's homework for the rest of the year. Go find a pincushion stop sign. Let's bring our pictures back. So, obviously, I'm here in my office because it's gone dark on me. Someone thought that we ought to protect the environment and put automatic switches that like to turn off when I don't move. So, we'll see you guys January 8th. Have a wonderful Christmas holiday and rest of your December.
Awesome.
Merry Christmas and Happy
Yep.
New Year.
Thank you.
Merry Christmas.
Thank you.
Thanks, guys. We'll see you.